Good evening. My name is Tahir Qureshi. I'm a fellow Rules Issue of Canada broker of record for City Pro Realty Brokerage. My passion is real estate and your success is my priority. I'm a host of Realty Coffee Talk. Tonight's subject is disclosure and conflict of interest in Ontario real estate. So stay tuned. I'm going to share my screen and then we're going to start the program and you're going to love it. Let's go back. Sorry, here, right here. So we're going to start the program beginning of the slide. So disclosure and conflict of interest in Ontario real estate, sponsored by City Pro Realty Brokerage. I am the host of Realty Coffee Talk for the past many years, and you're going to like this topic. The disclosure conflict of interest in Ontario real estate. Why is it important? The failure to properly disclose conflict of interest in real estate transaction may adversely influence a party's willingness to proceed with the agreement of purchase and sale or a lease. As such, pre-contractual disclosure is paramount. This webinar addresses the registrant's mandatory obligations and highlights the importance of consumer education, specifically the need for purchasers and tenants to seek clarity and ask probing questions prior to execution of documents. So disclosure and conflict of interest in real estate. In Ontario, the real estate professionals are governed by Trust in Real Estate Services Act 2002 and its Code of Ethics, which established a strict legal framework for handling conflict of interest and mandatory disclosures. In such case, the guiding principle is the agent's paramount duty to promote and protect clients' interest. A conflict arises when there is a risk that this duty is compromised by the agent's personal interest or duties to another party. And this is why this topic is very important for registrant as well as for consumer. What constitutes a conflict of interest? Let's explore that. The definition is broad and can encompass any situation where an agent's judgment, agent means broker, broker of record, sale agent, judgment could be impaired. Key categories specifically address the regulation includes. I'm going to include those here. Multiple representation. When one designated broker or agent represent two buyer and seller, landlord and tenant, is called multiple representation. Personal trades and property interests. When there is an interest in a trade where either you are in conflict with the acquisition of the property or disposition of the property. So this is very important. Number 3, financial benefit. That we as a registrant have a financial benefit. Well, I have identified those forms, and toward the end of the program, we're going to show you those forms and we explain them as well. Financial benefit. So what constitutes a conflict of interest occurs when a brokerage or designated agent represent more than one client in the same trade, that is a seller and a buyer, a landlord and a tenant. The agent becomes facilitator who cannot advocate for either client's best interest, particularly regarding price or terms when you are preparing offer. So this is very, very important to understand that multiple representation. So be careful when we're going to talk about the forms at the end. Personal trade and property interest. If an agent is buying or selling a property for themselves, they must provide written notice to all parties, disclosing their license status and all material facts affecting the property's value. Furthermore, they must disclose to the client any property interest their brokerage or a related person holds in the property the client is considering. A buyer or a tenant is considering a property, or landlord or a seller disposing of a property, the disclosure needs to be made. I'm going to talk about the forms toward the end of the program. Agent must disclose any direct or indirect financial benefit they or related parties might receive from a third party concerning the services they provide to a client. Financial benefit. Example is that if you make a referral for the mortgage and you collect the money, you're going to connect the money after transaction is completed. You must disclose and get the consent. I'm going to talk about that form there. I have gathered the ORIA form so I can show you whether you are representing a buyer or a seller, or you're representing a landlord or a tenant. Those disclosure needs to be made. Mandatory process for managing conflicts. When a conflict or potential conflict arises, the agent cannot proceed with providing services until they have been completed a specific four-step process. So I'm going to explain this four process, and I'm sure you are, being a registrant, you're familiar with that. But when you are dealing with a client as a consumer, and this message is for both consumer and registrant to use this, remind your agent. And this is very important. Now, what step? Let's talk about first. Step one, disclosure. No matter what it is, you need to disclose that. It's a latent defect as a seller. For example, your property is finished by a past owner. It's an apartment building, but there is no license or there is no building permit. So the buyer will assume that risk. You have disclosed that. We don't have a permit. You have disclosed that. Example. Advice on independent professional advice. We're going to talk about each one item. When you are asking for accountant or legal advice, especially in conflicts of interest, there's a monetary reward available and there is a lawyer opinion. So you recommend them go seek advice from the lawyer or other competent professionals. Verify understanding. You want to make sure disclosure that doing a conflict of interest is understood by the parties involved. And how you do that? Obtain consent, written consent, that I have disclosed multi-representation, I have disclosed the benefit, financial benefit, I disclosed that I recommended them to another consultant, engineer, environmental professional, lawyer, an accountant, whatever that conflict is, depends on the property, it may varies. But get the written consent. How you do that? We're going to talk about that. So mandatory managing process, and the agent must provide a clear and complete written disclosure of the circumstances giving rise to the conflict to the client or prospective client. This disclosure must be clearly identified by the prominent placement of the word disclosure. And remember, Uriah has created those forms. We're going to talk about that after this. So basically, disclosure. Disclose anything that creates a conflict of interest or there are latent defects. You are buying the property, you're selling the property, you have interest, disclose it. Or you're doing a multiple representation. The agent is required to advise the client to seek independent professional advice. That is from a lawyer or accountant. The agent must clarify they cannot provide advice on the conflict itself. So you have conflict here in this, in terms of there is advice, go to the lawyer, go to the accountant, is a financial matter, go to the inspector, home inspector, or to the appraisal, whatever that you have. Because you as a licensed, as a real estate professional, you cannot give opinion about other jurisdiction or competency. This is why you ask them to seek independent advice. Why? Advice on independent professional advice, because you don't have the competency. I'm a principal broker of Canada Express Mortgage, Inc. My license is M08-003-2130, and FISRA license is 13241. So I can talk about the mortgages because I have a brokerage, I have a license. And this is why it's important for you, if you don't have a license, make a referral to another competent professional. The agent must take reasonable steps to ensure the client demonstrate a clear understanding of the conflict and its implications. This could involve asking clarification questions to confirm comprehension. So make sure when you are explaining multiple representation and you are representing buyer and seller, you explain to them that we're not going to disclose any motivation why the buyer is giving the offer, why the seller is going to sell for less than what he is asking for. So you cannot discuss any price consideration. I recommend that you put a clause there for a lawyer on both parties and give notices to the lawyers and let them get your client to acknowledge them. So you're protecting yourself. You're not giving opinion. You're only sharing factual information that is readily available. Verify understanding. They need to understand they understood what you're talking about. And if they still want to proceed, then the agent must obtain the client's informed consent to continue with the services. The client is under no obligation to consent, and if they refuse, the agent cannot proceed. So this is why I recommend that when you are working in a brokerage and you have, try to ask another broker who can represent the buyer, so to avoid multiple representation. But if the buyer insists that they want to work with you, then you have to have a multiple representation consent from landlord, from the seller, the buyer, and the tenant. Obtain consent. And we have form. Uriah has form. We're going to talk about those forms as we talk. These rules are strictly enforced. For instance, a failure to properly disclose a conflict can expose an agent to significant legal liability and professional discipline. If you did not disclose, your client will complain to RICO. A recent regulation update, TRESA, came in 1st December 2023. TRESA have strengthened its professional obligation, emphasizing integrity and prevention of fraud to enhance consumer protection. So this is all about disclosure and conflict of interest in the best interest of your client and to protect your integrity, professionalism, good ethic, and business practices. Disclose your conflict of interest. So we're going to talk about form, URIA form, because we are member of URIA through TRAB or other software or boards. You have access to them, and you, as a member, use these forms. So Form 160, registrant disclosure of interest, acquisition of the property. When you're buying a property, get this form prepared and get it signed by the seller, because you are acquiring a property. So you buyer, you send this out, have your broker record sign it, and let the seller or the tenant sign this. Form 161, registrant disclosure of interest, disposition of property. If you are representing a seller, you do this form, because you have to tell the buyer that I am related to the seller, or my spouse or yourself, whoever has interest in the property, disclose this form. Form 170, consent to advertise, buyer and seller. So when you advertise the property after it is sold, you need to have a consent. Use this Form 170. A lot of people put this in Schedule A. Buying and selling has nothing to do with the consent to advertise. It should always be separate. What will happen if buyer refuses to give consent? They want the property and somehow you refuse it because you have a relationship with the seller. It may rise to a complaint against you because you are avoiding a buyer to participate in the offer, because buyer and seller has nothing to do with this. Advertisement has to do with the seller agent or brokerage and the buyer. So entertain it. Get this consent, advertise, and then you advertise. Form 299, seller disclosure. This is very important, latent effects. Lots of people have problem, leakage in the basement, flooding the basement, sewer problem, or basement is not built with building permit, there's no occupancy permit, there's no second dwelling unit. Disclose it. This is your time as a seller agent to disclose that you don't have a building permit, whether the client has built it themselves or maybe they acquired the property. At that time, there was no building permit, because the buyer have to assume that if there is no building permit, that means they have to obtain a building permit. If they want to rent out, it's going to cost them a lot of money. As you know, I am founder of Tixon Construction. I'm a licensed builder with SCRA, license number B63247. I'm a builder. I know this, that when you have illegal basement and you rent it and there's a fire, house burned down, the landlord or the seller will not get a penny, because they let them rent the property to someone without a building permit. And buyer needs to be aware that they will seek the disclosure before they make a decision, because there will be a cost involved. So Form 325, multiple representation, seller acknowledgement and consent. When you have a seller client and you are telling the seller client that I have a buyer, or the brokerage has a buyer who will buy the property, therefore we need your permission, acknowledgement, and consent that we are going to proceed, if they allow you to do that or not. If they allow it, yes, you proceed. If they don't, then you recommend them to another agent within the brokerage or brokerage outside your brokerage. You need to be very ethical, professional, demonstrate integrity, professionalism, and good ethics because your obligation is protecting the interest of your client. Similarly, if you're in multiple position, if you're a seller, you need to disclose to the buyer and get them acknowledge consent before you proceed. Agents are very familiar with that. Which form is this? Similar, Form 327, multiple representation landlord acknowledgement. When you are leasing the property, you need this acknowledgement from both parties. Form 328, multiple representation, tenant acknowledgement and consent. You cannot proceed if you're doing a multiple representation. And this is talking about financial benefit. Form 610, disclosure of benefit, payment to registrant, finder's fee, reward fee, referral fee, incentive. Primarily, you recommend someone for mortgage financing, and then you get some benefit. Payment has to go to the brokerage. So this form has to be signed by your client, especially the buyer, because he's the one who's buying it, that you will be receiving incentive. So I created this form so these forms are identified, so it's very easy for you to use.
To learn more about real estate and mortgages, please visit Realty Coffee Talk and subscribe to my YouTube channel. Thank you.
So again, disclosure and conflict of interest in Ontario Real Estate, sponsored by City Pro Realty Inc. Brokerage. I would say that we have hundreds of episodes now on my YouTube channel. You can go to youtube.com/Realty Coffee Talk, or you can go to realtycoffeetalk.com and learn. Start learning today. I would like to take this opportunity to thank you very much for watching. We look forward to your valuable feedback and collaboration. You can go to realtycoffeetalk.com, or you can send me an email at realtycoffeetalk.com. I will respond to you. The aim of Realty Coffee Talk is to increase awareness, building consumer confidence in buying and selling real estate and mortgage financing and new home construction. Thank you for watching. We appreciate your feedback. Thank you very much. Bye for now.